The discovery phase of a slip and fall lawsuit. How the discovery phase of a slip and fall lawsuit works, and what it involves. As in most civil lawsuits, the discovery phase of a claim refers to the period of time when the parties who are involved in the slip and fall claim learn as much as they can about the slip and fall. A discovery phase can last as little as a few months, or as much as a few years, depending on how complex the case is, and how busy the court is. If the court has a lot of pending lawsuits, it may be that the discovery phase lasts longer than originally intended. Interrogatories. Interrogatories involve the plaintiff, the individual who had the fall, and the defendant, the party the plaintiff is suing, answering questions under oath. During the interrogatories, your attorney will submit some questions to the defendant in a bid to learn more about the premises or location where you had your fall. The questions are also likely to ask if the owner had notice of, knew about, the dangerous condition, if applicable, that existed on the premises or location. The defendant will be represented by a defense lawyer who will submit questions so that they can learn whether you knew about a dangerous condition and if you were careful. It is highly likely that they will also ask if you have any physical illnesses or conditions that could mean you were likely to fall. You should expect to be asked about your medical history as it may be relevant to your claim. Requests for production. Requests for production are requests that have been written, and they ask for documents that could be related to your claim. For example, during your claim, your attorney may ask for surveillance footage of the area where you fell. They may also ask for incident reports that detail your fall and any other incidents that took place in the area. Your attorney may also ask for documents that relate to the maintenance of the premises, and any company policies that relate to property inspection and maintenance. Medical records. A defense lawyer may ask for the medical records that show the treatment that you received after your slip and fall. Evidence such as this can be valuable as the records will detail your injuries, your doctor's opinion of how severe your injuries are, and how they think they were caused. It is also likely that the medical records will include your description of how you fell, which can be very useful to the defense lawyer. The defense lawyer will also be interested in your medical history, especially if it contains evidence that you have a history of blurred vision, brain disorders, diabetes, dizzy spells, epilepsy, fainting, high blood pressure, muscular disorders and a history of falls. If there is evidence of the above conditions in your medical history, the defense attorney could claim that they caused your slip and fall. Depositions. Depositions involve lawyers asking witnesses questions under oath. The questions and responses will be recorded by a videographer and a court reporter. At this stage of the discovery phase, the defense lawyer will ask almost everything and anything about your fall. The defense lawyer may ask you, "Do you know what caused your fall? If you know, when did you see it? What dangerous condition do you say caused your fall? What evidence do you have that shows the owner of the property was aware of the dangerous condition when you fell? What precautions, if any, did you take to avoid the dangerous condition? Which part of your body hit the ground, if applicable, first? What kind of shoes were you wearing when you fell? What else were you wearing when you fell? Do you need to wear prescription glasses? What was the weather like when you fell? Were you distracted when you fell? What did you do right after your fall? What medical treatment did you receive? Do you still have injuries?" A deposition can seem quite difficult and challenging, and it could last as much as 8 or 9 hours. Some attorneys will appear to ask you everything under the sun, including questions that may not seem related. It is the attorney's job to ascertain exactly what happened and when so they can try to prove that their client, the defendant, is not liable. The independent medical exam. If the defense lawyer disputes your injuries, it is likely that they will ask you to undergo an independent medical exam. A doctor who has been paid by the defendant's insurance company may be selected and asked to evaluate your injuries. While you may be worried that the doctor will offer an evaluation that favors the defendant, it is not in the doctor's interest to do this. No doctor wants a reputation for being paid to favor a defendant, so it is very unlikely that this will happen. An independent medical exam can be very beneficial to your case, especially if the exam confirms that you have the injuries you say you have. However, if it is found that you do not have the injuries that you allege you have, the case is unlikely to run in your favor. If you think there is a chance you may be asked to undergo an IME, please make sure that you do not exaggerate or fabricate any injuries. If it is found your injuries do not exist or they are not as bad as you alleged them to be, you could lose the case, and you may have to pay all of the court costs. If you are about to enter the discovery phase of your slip and fall lawsuit, you may find the above information very helpful. Please bookmark this page so you can return to it should you need to.